Swayam Prabha. Digital India. Educated India.
Friends, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU, and this is my 34th lecture, and the topic which I am going to discuss before you, that is international and national norms for protection of women's right. So in this lecture I would like to highlight international instrument on protection of women's right and national norms, national parameters for the protection of women's right. So I have chosen this topic so that I can explain you each and every aspect of international law as well as Indian laws related to women's right. So you can see on your screen that right to equality is provided in Article 1 of UDHR 1948. So, according to Article 1 of Universal Declaration of Human Rights 1948, all human beings are equal by birth. So, females are also equal in eye of law. They are entitled to get all the benefits which male can get from the state. So, right to equality, Article 1, you can see on your screen. Right to life, Article 3 of UDHR 1948, right to education, right to marry, right to freedom of speech, right to education as a precious right, right to marry. Every woman has right to marry with her own choice. This is human right. Though this human right has not been expressly recognized under Article 21 of the Indian Constitution, but this right to marry by judicial pronouncement has got recognition under Article 21 of the Indian Constitution. Recently, Supreme Court of India has recognized right to marry as essential component of right to life under Article 21 of the Indian Constitution. So this is another important thing which you need to remember. Women are entitled to avail this freedom of speech and expression. They have liberty to speak whatever they want, subject to the restrictions mentioned under Article 19, Clause 2 of the Indian Constitution. Right to vote, women are entitled to participate in electoral process. They have right to cast their vote. So states shall not make any kind of discrimination on the ground of caste, sex and race, birthplace. Right to fair wages, as I have just highlighted in my previous lecture that women are entitled to get fair wages, remuneration. They are entitled to get equal pay for equal work. This is human right of female are also entitled to get this benefit. And I just want to give comparative chart so that you can understand that what is international perspective on women's right and what is Indian perspective on women's right. So women has right to get fair wages. All the women are entitled to get fair and reasonable wages, remuneration, right to vote. Article 326 of the Indian Constitution talks about right to vote. So women are also entitled to cast their vote as per the mandate of Article 326 of the Indian Constitution. Right to reasonable and fair wages, equal pay for equal work, equality, they are equal in eye of law. Article 14 is specifically talks about right to equality as a fundamental right. So they are equal in eye of law. So for that purpose, Indian Parliament has enacted the Equal Remuneration Act 1976. By that special legislation, Parliament has provided that states shall not make any discrimination on the ground of sex. Male as well as female both are entitled to get equal pay for equal work. This is right to reasonable and fair wages, right to health. So women are entitled to get nutritious food, and it's state responsibility to ensure their nutrition level. This is provided in Part 4 of the Indian Constitution. If you have any idea, you might have seen that provision regarding providing food and maintaining nutrition level is given in Part 4 of the Indian Constitution, which talks about DPSP, Directive Principle of State Policy. Now come to women's human right under Indian legal framework. Right to equality, Article 14, you can see on your screen. Right to freedom of speech and expression, Article 19. Right to life or personal liberty, Article 21 of the Indian Constitution. Right against exploitation. Women are entitled to live with human dignity. They have right to not to be exploited by state or by individual. So protection against exploitation, this is another important right provided under Article 23 of the Indian Constitution, which female are entitled to avail these rights. Right to marry, 21. Right to education, Article 21A. Right to health, Article 21. You might be knowing that Supreme Court for the first time in Permanent Katara versus Union of India held that right to health is a fundamental right, and without completing medico legal formality, it is the responsibility of all the hospitals, whether it is government hospital or private hospital, to provide first medical aid to the victim, to the injured person. So right to health, a right to shelter, these rights which women can avail under our legal system. So I will discuss one by one. Protection of women's right under Indian legal framework. You see, women's human right under Indian legal framework, constitutional scheme, protection of women's right under Indian legal framework. So what are, in this lecture I would like to highlight what are those statutes which have been enacted by the Parliament in order to protect rights of women in this country. So the first important legislation which you all might be knowing, that Indian Penal Code 1860, you can see on your screen. Indian Penal Code has specifically provided that in case of violation of rights of women, whether in case of molestation, section 354 IPC makes it offense, makes molestation as an offense, crime. Where rape is committed, the word rape is defined under section 375 of the Indian. Miscarriage without consent of female is an offense under section 312, 313. Causing hurt or grievous hurt, assault. So these are certain offenses which are, if these offenses are committed against women, women as a victim of crime, can file a complaint or lodge FIR at the police station, and she can take shelter of the court in case of violation of her rights. Second important, I have just chosen these few legislations so that I can explain you in brief. Another important legislation is the Equal Remuneration Act 1976. The Equal Remuneration Act 1976 was enacted by Parliament in 1976 to provide equal pay for equal work to women. I have already highlighted this statute. The Protection of Women from Domestic Violence 2005. Protection of Women from Sexual Violence at Working Place. These two legislations are very important, which I will try to explain you. Now come to this equal pay for equal work. This is the mandate of the Constitution. Article 14 talks about right to equality. So in the light of Article 14 of the Indian Constitution, Parliament has enacted this special legislation, right to equal pay for equal work, Equal Remuneration Act 1976. That act was enacted by Parliament in the light of this constitutional provision, constitutional guarantee, Article 14 of the Indian Constitution. Article 15 clause 3, you can see on your screen that Article 15 clause 3 talks about establishment, enactment of special legislation for women and children. I just want to explain Article 15 clause 3, what is actually written in Article 15 clause 3. Nothing in this article shall prevent the state from making any special provision for women and children. Have you got my point? Article 15 clause 1 says that state shall not make any discrimination on the ground of race, caste, sex and religion. So under Article 15 clause 1, state is prohibited from making any law on the ground of race, caste, sex, religion. On the other hand, Article 15 clause 2 says, 15 clause 3 says that nothing in this article shall prevent the state from making any special provision for women and children, meaning thereby state can make special legislation for the betterment of women and children. It means state here means Article 12 of the Indian Constitution, Parliament, state legislature, local bodies, local authorities, other authorities. So Parliament or state legislature are free to make special legislation, special law for women and children. In the light of this, Parliament has enacted the Protection of Rights of Women Act, National Commission for Women NCW Act, State Commission for Women. In that National Commission for Women Act 1990, there are two types of commission, National Commission for Women and State Commission for Women. These two commissions are dedicated to protect the rights of women. Now come to Domestic Violence Act 2005. Domestic Violence Act, that is a milestone. This is a big achievement for women organization. Indian Parliament, in order to provide justice to Indian women and considering the plight of Indian women, Parliament has enacted the Protection of Women from Domestic Violence Act. In brief, this act is also referred as Domestic Violence Act 2005. So the appropriate the name of this legislation is the Protection of Women from Domestic Violence Act 2005. Briefly, it is also referred as Domestic Violence Act 2005. Quickly, I would like to highlight some salient feature of this act. Section 3 of this Act talks about domestic violence. Section 3 defines domestic violence. Any act or words is spoken by respondent which degrades the dignity of a human being, which degrades the dignity of women, would be considered as domestic violence. Respondent word has been used deliberately because many students have a common myth about domestic violence, that domestic violence is always committed by husband against wife. No, it is not at all. Domestic violence can be committed by husband against his wife, or this domestic violence can be committed by a brother against a sister. This domestic violence can be committed by a daughter against her mother. Mother may be victim where she is deprived from her financial benefit, or where mother is neglected by her daughter, where mother is neglected by her son, then son will be respondent, daughter will be respondent. Where a brother is, where a sister is neglected by her brother, is not taking care of his sister as well as mother would be at liberty to file a complaint in Domestic Violence Act 2005 against his sister against his brother, mother against her son. So here sister may be aggrieved, mother may be aggrieved, wife may be aggrieved from domestic violence. So you need to remember these things. The domestic violence complaint may be filed by a sister against his brother, against her brother. This domestic violence complaint may be filed by a mother against her son. This domestic violence complaint can be filed by a wife against her husband. So this is the actual position of this Domestic Violence Act. Who may be complainant? Who can file complaint? Wife, mother and sister. Now come to beneficiary under this act, which I have highlighted. Beneficiary under this act is wife against husband, mother against son or daughter, sister against brother. These are the beneficiaries provided under this act. Now what are the remedies available under this Domestic Violence Act 2005? Remedies available under this Domestic Violence Act is residence order, protection order, monetary relief, compensation order. Quickly I would like to highlight these four important remedies available to victim of domestic violence. Victim of domestic violence can file a complaint, can make an application regarding domestic violence to a judicial magistrate first class. Judicial magistrate first class is a competent authority designated under this act to accept the application pertaining to domestic violence. So judicial magistrate first class, after making due inquiry about allegation, about the complaint, that judicial magistrate can pass an order in favor of victim of domestic violence that she should be allowed to reside in the same house where respondent is residing. That order is referred as a residence order. So after having that residence order, she, mother or sister or wife, can live, can reside in the same house where husband is residing, where mother can reside. Mother, after having this residence order, can reside in the same house where her son is residing. In case of sister and brother, sister, after having this residence order, can reside in the same house where her brother is residing. If that order is not obeyed, then it would be a breach of order, and the consequences of breach of order is very tough in this act. Now second important order is protection order. Judicial Magistrate First Class, after the inquiry, can pass protection order in favor of victim. Protection order includes either respondent may be prohibited to visit the victim of domestic violence, or respondent can be prohibited to enter into the premises where victim of domestic violence is residing. Respondent can be prohibited not to go at that place where victim of domestic violence is working. If she is working female, then respondent can be prohibited that by that protection order, that he will not go, respondent will not go to that place where victim of domestic violence is working. In case of joint account, in case of husband and wife, if they have joint account, so husband can be prohibited by the court not to operate that account which both the parties are having. So in case of joint account, husband can be prohibited to operate that account. So this is the protection order, and after having protection order, victim of domestic violence is safe, and respondent will think twice to breach any order mentioned in that protection order. Protection order is, you see, protection order is a kind of guarantee given by the court to the victim of domestic violence, so that she can live safely, so that she can enjoy her rights provided in this act. This is the protection order. Monetary relief, this Judicial Magistrate First Class, after making the inquiry, if magistrate thinks fit that victim of domestic violence is not in position to maintain herself, she needs financial assistance, so Judicial Magistrate First Class may pass an order for monetary relief in favor of victim of domestic violence, and victim of domestic violence can get that monetary benefit, monetary relief from the respondent. In addition to this, compensation order can also be passed by Judicial Magistrate First Class, and after having this compensation order, a victim of domestic violence can get compensation from the respondent. This compensation order is in addition to monetary relief. In compensation order, Judicial Magistrate can award compensation for the loss or injury suffered by victim of domestic violence. So this is a very good act, effective legislation, where victim of domestic violence can make an application to the competent authority, and competent authority can pass either residence order, protection order, monetary relief, compensation order, considering the requirement of that victim of domestic violence. Judicial Magistrate First Class can take any appropriate decision for the betterment of victim of domestic violence. So I think that you all have understood the rights available to female under this Domestic Violence Act. Now come to third important aspect, that is the role of Supreme Court in protection of women's right. So in this slide, I have highlighted those judicial pronouncements through which Supreme Court has played significant role in the recognition and protection of rights of Indian women. First of all, I would like to discuss an important case, that is Vishakha versus State of Rajasthan, AIR 1997. Second important case is Bodhisattva Gautam versus Subhra Chakravarti, AIR 1996, Supreme Court. With the help of these two judicial pronouncements, I would like to substantiate my argument that Supreme Court has played significant role in recognition as well as in protection of human rights of Indian women. So firstly, I would like to take Vishakha versus State of Rajasthan case. What actually happened in this case? Vishakha is an NGO. What actually happened in this case? A village head named Bhauri Devi, she had been involved in raising voice against child marriage in Rajasthan. So she had a noble cause, she had a noble purpose. So she was involved in making people aware about child marriage and consequences of child marriage, and she had won many awards. But when she was trying to oppose a child marriage, local resident, they committed rape against her, and matter was brought into the notice of Supreme Court with the help of this NGO Vishakha. When Supreme Court asked the government concerned, when Supreme Court asked the state government of Rajasthan as well as central government that whether government is having any special legislation which can prevent, which can protect women from sexual offense at working place. When this question was asked by Supreme Court from the state government as well as central government that whether state government is having any special legislation or central government is having any special legislation for the protection of women from sexual violence at working place, central government as well as state government both, they replied negatively. They said that right now we do not have any special legislation on this. So Supreme Court, considering the plight of victim, issued direction in this case, Vishakha guidelines. That is very important guideline. Vishakha guidelines are very important for the protection of rights of women. Supreme Court held that unless these guidelines are legislated by the parliament, unless these guidelines become part of a statute, these guidelines shall be treated as law of the land, and guidelines are as good as law. Few important guidelines which I would like to highlight in this lecture, that every establishment, whether it is government establishment or private establishment, will have to have women grievance cell. Since then, every government as well as private establishment, factory, industry or any establishment, institution is having women grievance cell. For what? For the redressal of grievances of women who are suffering from this kind of act. So this is one important, and it is the duty of employer to ensure that respondent should not visit that place where victim of sexual offense is working. So he may be, it is the duty of employer to transfer that respondent, if both are working, respondent and victim are working in same establishment, then respondent can be transferred from that place, can be prohibited to visit that place. So these are certain guidelines which are important for you to remember. Second important case is Bodhisattva Gautam versus Subhra Chakravarti, AIR 1996, Supreme Court. What happened in Bodhisattva Gautam versus Subhra Chakravarti? This is a very leading case on, in this case Supreme Court for the first time held that even a rape victim is entitled to get interim compensation from the accused till the disposal of cases. So this case is important. Supreme Court for the first time in 1996 held that even a rape victim is entitled to get interim compensation from the accused. Now come to another aspect of human right of women. Women are also entitled to get free legal aid. Right to legal aid as a fundamental right. You all might be knowing that legal aid in criminal matters, it is an important right in the hands of accused, where accused is poor, unable to engage his counsel before the court fee, unable to deposit court fee. So section 304 CRPC talks about free legal aid to the accused in criminal matters. Section 303 CRPC talks about legal representation. Every accused has right to engage his counsel of his own choice. Article 22 of the Indian Constitution also says that every person has right to have a counsel of his own choice. So Article 22 says that every person has right to have a counsel of his own choice, a legal representation of his own choice, can take advice from advocate of his own choice or her own choice. This right to legal aid as a fundamental right was recognized by Supreme Court in Hussain Ara Khatun versus State of Bihar, AIR 1979 Supreme Court. You see what happened in this case. Hussain Ara Khatun, she was an accused. She was languishing in jail of Bihar, and since she was not in position to fight her case, so her case was brought into the notice of Supreme Court by Kapila Hingorani. Kapila Hingorani is considered as mother of PIL in India. So she decided, Kapila Hingorani being a leading lawyer at Supreme Court, she decided to fight her case. She decided to fight case on behalf of Hussain Ara Khatun, and she fought her case. Ultimately Hussain Ara Khatun got justice with the help of Kapila Hingorani, and Supreme Court for the first time held that right to speedy trial is essential component of right to life or personal liberty. Merely recognizing right to life as a fundamental right under Article 21 of the Indian Constitution would be meaningless for those poor people who are unable to get justice due to poverty, and they are languishing in jail, they are waiting for their trial. It would be violation of their precious right guaranteed under Article 21 of the Indian Constitution. So considering all these things, Supreme Court for the first time held that justice delayed is justice denied. So right to speedy trial is a fundamental right, and it is the duty of court to decide case expeditiously. Since then, right to speedy trial is considered as essential component of right to life or personal liberty guaranteed under Article 21. So I think you all have understood this case, Hussain Ara Khatun case. Now come to another important rights of women which they are entitled to get under Indian criminal justice system, that is legal representation. And one important thing which I will try to explain you, because Bharatiya Nyaya Sanhita 2023 has come into picture. Parliament has enacted Bharatiya Nyaya Sanhita 2023 in place of Indian Penal Code IPC 1860. Now IPC has been repealed and we have new legislation on that, that is Bharatiya Nyaya Samhita 2023. Second important legislation is Bharatiya Nagarik Suraksha Samhita 2023. So I would like to highlight certain important rights of victim of crime provided in this Bharatiya Nagarik Suraksha Samhita 2023, so that you can get entire information regarding rights of women. Section 360 of Bharatiya Nagarik Suraksha Samhita 2023 is very important at this point of time, because section 360 of Bharatiya Nagarik Suraksha Samhita 2023 says that no criminal court shall withdraw any prosecution unless victim of crime is provided opportunity of hearing. You see, this provision was not in previous code, the Code of Criminal Procedure CRPC 1973. Now, what will happen? Earlier government used to withdraw prosecution against the offender. Now it is not possible unless the victim of crime, suppose victim of crime is a female woman, so where women has raised objection at the time of withdrawal of the prosecution, that prosecution cannot be withdrawn. This is the first important amendment. You see the first important right which victim of crime and female being a victim of crime can raise objection at the time of withdrawal of criminal cases. Second important provision is that a victim of crime can make appeal in case of acquittal where accused is acquitted. Jahira Sheikh is a good example on this. And where Madhu, you see this right to make an appeal in case of acquittal, where accused is acquitted by the court, or in case of lesser penalty, lesser punishment, inadequate sentence, the law is that state will have to make an appeal against acquittal order, or where sentence is inadequate, state will have to make an appeal. But where state is not making appeal in such a cases, then in this new Bharatiya Nagarik Suraksha Samhita, victim of crime, if victim of crime is female, women, then she is at liberty to make an appeal against the order of acquittal, or in case of lesser sentence, lesser punishment. So she can make an appeal against that order. So these are two important things which you all need to remember. Third important thing is that victim has right to get compensation. As I have already highlighted that Bodhisattva Gautam vs. Subhra Chakravarti IR 1996, that is a very leading case on this. So Bodhisattva Gautam vs. Subhra Chakravarti, in this case Supreme Court for the first time, in 1996, Supreme Court for the first time held that rape victim is entitled to get interim compensation from the accused. In this new code, Bharatiya Nagarik Suraksha Samhita 2023, victim of crime has right to get compensation from the state or from the accused, as the case may be, depending on case. Let us understand, earlier in CRPC, in the Code of Criminal Procedure 1973, section 357 provided that compensation would be obtained by victim of crime, and criminal courts were at liberty to, even this act is, this Samhita will been notified on 1st July 2024, but still section 357 CRPC is still prevailing. So let us read section 357 CRPC, that criminal courts may award compensation in criminal cases. I am referring new provision of new statute, that is Bharatiya Nagarik Suraksha Samhita, where offender is not identified or not traced. Offender has absconded. Victim is identified. Victim is a woman, identified. Offender has absconded, not identified, not arrested. In that case, if application is made by that victim to the police, FIR is lodged at the police station, police officer, after the receipt of that application, can make application to the District Legal Service Authority for what? For award of compensation. So District Legal Service Authority, with the help of that application which victim of crime has made to the District Legal Service Authority, and with the help of injury report prepared by a doctor, because that injury report, medical report, would be helpful for District Legal Service Authority to award amount of compensation, to fix quantum of compensation to the victim of crime. So where a report is made by police officer to the District Legal Service Authority, application is also made by victim of crime, then District Legal Service Authority or State Legal Service Authority can award compensation to the victim of crime. Second important thing is that where offender is arrested, trial begins, and at the end of trial, if court is of the opinion that victim of crime should be awarded compensation, or compensation awarded is inadequate, then that trial court will make a recommendation to District Legal Service Authority or State Legal Service Authority, as the case may be, for what? For the award of compensation. So these two things you must remember. Where compensation is awarded by criminal court during the trial, after the conclusion of trial, if compensation is awarded, if that compensation is not adequate, even on that ground, even on the ground of inadequate compensation, victim of crime can make an appeal for the enhancement of amount of compensation. So this is another important aspect of compensation where victim of crime can get. Next important section 396, 397 is important, which talks about treatment. So state government in coordination with central government will prepare a scheme, compensation scheme for the award of compensation to the victim of crime. Another significant changes which have been made in this new law, Bharatiya Nagarik Suraksha Samhita 2023, that is treatment of victims. Where victim of crime has suffered loss or injury and crime is pertaining to sexual offense or offense has been committed against a child, POCSO Act is to be applied, then in that case, it is the duty of competent authority to provide first medical aid to the victim of crime. So medical facility shall be provided by competent authority free of cost in case of sexual offences. This is another important aspect where victim of crime can get assistance, medical assistance from competent authority. And this is the mandate of section 397 of the Bharatiya Nagarik Suraksha Samhita 2023, that all the hospitals, government as well as private hospitals, without making any formality, without making any delay, they shall immediately provide medical assistance free of cost to rape victims, to the victims of crime. And so this is very important provision in this new criminal law. And the last important things which have been added in this new criminal law, Bharatiya Nagarik Suraksha Samhita 2023, that is preparation of victim protection scheme. So state government in coordination with central government shall prepare victim protection scheme so that victim cannot be harassed, cannot be threatened, so that fair trial can be conducted. The ultimate purpose of criminal justice system is to conduct a fair trial and to ensure impartial justice, and no fair trial can be conducted in the absence of witness, where witnesses are threatened or witnesses are harassed by the offender or the relatives of the offenders. Then it would be difficult for the courts to conduct trial fairly. So in order to ensure fair trial and ensure impartial justice, Parliament has inserted this provision that every state government will have to prepare a witness protection scheme in coordination with central government. You all might be aware that Ministry of Home Affairs in 2018 has already prepared a scheme. That name of that scheme is Witness Protection Scheme 2018. By that scheme, Witness Protection Scheme 2018, threat has been categorized into three categories. The first is where threat is regarding death. Second is where threat is pertaining to destruction of property or reputation of the victim, witness. And third is petty offences. So that threat report will be prepared by DCP or by ACP, Deputy Commissioner of Police, or DSP, Deputy Superintendent of Police, or ACP, Assistant Commissioner of Police. That threat analysis report will be prepared by this authority, and on the basis of threat perception, there is a time limit. DSP or ACP shall prepare that report within 5 days from the date of receipt of the application. Once the application is made by a witness to the police that he or she should be provided protection. So particularly if application is made by female victim, women victim, witness, so that a report shall be prepared by DSP or SCP within 5 days from the date of receipt of that application. Additional time cannot be taken by DSP or SCP. So matter should be disposed of expeditiously, and after accepting that application, matter will be sent to the head of the department, head of the police of that district, and protection shall be provided to the witness. So that protection may include either police patrolling may be allowed, police may visit that place where witness is residing, or phone calls, mail or email, WhatsApp may also be accessed by the police, whether just to see whether offender is making any phone call or mail to threat to the witness. These are the safeguards provided to the witness in this witness protection scheme. The most important thing is that this witness protection scheme 2018 contains a format of application. In that application, there is no need to write an application by the victim. Just application is attached, a format of that application is attached to that scheme. Anyone can download that application from website, and that witness can write his or her name, his address, her address, mobile numbers, and nature of threat, whether threat was related to his death or reputation or damage to the property. So he or she can specifically mention the nature of threat in that application. The area where she is residing, if she has idea about, if she is aware about the name of the offender, then she can also mention the name of the offender, place of the offender, all the identity of the offenders, so that police officer can warn him. So this is, you see, this is the kind of protection available to the witness in this witness protection scheme 2018. So I think that I have covered each and every aspect of rights of women under this criminal justice system. I have highlighted not only international perspective on protection of rights of protection of women's right, but I have also highlighted national norms on protection of women's right. So firstly, I highlighted Universal Declaration of Human Rights, UDHR 1948, International Covenant on Civil and Political Rights 1976, especially provisions especially connected to the protection of rights of women. Then after I discussed constitutional safeguards provided to women in this country, how Indian Constitution has been effective in protection of women's right. So for that purpose, I have highlighted Article 14, right to equality, Article 15, Clause 3. I also highlighted Article 21, 22. Then after, role of Parliament, what are the statutory provisions, what are the statutes under which women are specifically protected. So for that purpose, I discussed two important statutes: Indian Penal Code 1860, Domestic Violence, the Protection of Women from Domestic Violence Act 2005, the Protection of Women from Sexual Violence at Working Place 2013. So I didn't discuss this statute in detail, but that is also an important legislation. Then after, I discussed the role of Supreme Court, role of judiciary, how Supreme Court has played significant role in recognition and protection of women's rights. So in that context, I referred Vishakha case, Vishakha guidelines, so that you can get entire information pertaining to sexual offense at working place, Vishakha guidelines. And then after I discussed Bodhisattva Gautam Subra Chakravarti case, I also discussed Hussain Ara Khatun versus State of Bihar case, so that you can get entire information pertaining to right to speedy trial as a fundamental right under Article 20 of the Indian Constitution, and right to legal aid, right to free legal aid. And then after I discussed Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita 2023, rights of victim of crime, where women is a victim of crime, then what rights, what remedies are available in this new criminal law, what remedies are available to a women victim under this Bharatiya Nagarik Suraksha Sanhita 2023. So in that context, I have referred 4 important rights: right to compensation, how she can get compensation from the accused or from the state, from the district legal service authority, how she can make an appeal where accused offender is acquitted by the court, how she can make application at the time of withdrawal of the prosecution against the offender, how she can get medical assistance, medical facility free of cost from the government, how if a female is a witness, she is going to appear before the court to record her statement. So being a witness, how she is protected. So for that purpose, I have also highlighted one important scheme, Witness Protection Scheme 2018, so that you can understand each and every aspect of rights of Indian women provided under Indian Constitution, provided under the statute and rule of Supreme Court. So with this, I do believe that you all have understood the things which I have just discussed in this lecture. Assuming that you all have understood, and if you have understood all these things, I do believe that you can clear any examination related to this human rights and rights pertaining to women in this country. With this, I would like to conclude this lecture. Thank you all.
When Copernicus said the earth revolves around the sun, it was considered blasphemy. When Galileo said the earth was round, we thought he was mad. When Darwin said that monkeys are the ancestors of man, we thought he had lost it. When the ecologists said this was the end of the world and the human race, we didn't believe them.